So I'll turn it over to Talita Diaz, our first speaker, who will be sharing a PowerPoint with us. Thanks, Talita.
Thank you so much, Aya, for the introduction, and thank you so much for inviting me to join the discussion today. It's a pleasure to be here. Today I'll be talking about international protections against cyber electro-interference. So as you can see, the focus of my presentation will be on international law, and in particular, obligations to protect from threats against electoral processes. So this will be the focus of my presentation. And as you can see on the logos here, the work that I'm presenting today has been done within the Oxford Institute for Ethics, Law and Armed Conflict, which is an institute at the Blavatnik School of Government at the University of Oxford. And it has been co-sponsored by Microsoft as well as the government of Japan. Now, just to give you a little bit of an outline of my presentation today, I'll start talking a little bit about the factual background surrounding the issues, the legal issues that I'll be discussing. And then I'm going to turn on to what we call the Oxford Process on International Protections in Cyberspace, which is an initiative that we established here at the Oxford Institute for Ethics, Law and Armed Conflict, along with other scholars and institutions in the world. And then I'm going to talk a little bit about the Cyber Due Diligence Project, which basically undergirds our research into protective obligations in international law. Then I'm going to apply this research to electoral processes in general. And then we're going to talk about one of the main outcomes of our research, which is the Oxford Statement on International Protections Against Foreign Election Interference Through Digital Means. Right. So starting with a little bit of background, which is always important when talking about these intricate issues, you've probably heard of some famous malicious cyber operations that have been carried out in the past by a number of non-state and state actors. And so it basically all started back in 2007 with the famous Estonia attacks against government websites and e-government services. And this was a massive distributed denial of service attack in response to the removal or the move of a famous Soviet statue in Tallinn, Estonia, and the damage was significant because for a number of hours, different government services and media outlets were shut down for a while. Then you've probably heard of the Stuxnet attacks. So this was basically a malware attack against industrial control systems in Iran back in 2010, and the malware it's alleged to be have been manufactured by the Israelis and also by the Americans. And the result of this attack was to shut down some nuclear enrichment centrifuges in Iran. So that was significant damage here too from these cyber operations. And then you've probably heard of the WannaCry ransomware attacks back in 2017, which affected inter alia a number of healthcare institutions, including the National Health Service here in the UK. Now, more recently, we've had cyber attacks against the healthcare sector during the COVID-19 pandemic, some related, some unrelated to the pandemic. So we've seen a wave of disinformation campaigns. We've seen attempts to steal the vaccines, different vaccine research and development initiatives around the world, including here in Oxford. And we've also seen the first death that has been directly connected to a ransomware attack in Dusseldorf, Germany, earlier last year in September. So basically a patient in this hospital was forced to move to another hospital because of a ransomware attack, and this patient died. So this is the first death resulting from a cyber attack, and in particular a ransomware attack. And then we've also seen over the past few years, more specifically, several instances of cyber electro-interference. So basically, different types of malware, different types of cyber operations being used to affect or interfere with electoral processes defined broadly. So basically, elections, plebiscites, referenda, and so on and so forth. Different manifestations of public opinion. So you're probably familiar with the 2016 hack against the Democratic National Committee. So this was an attack targeting mainly Hillary Clinton's emails, and the emails were leaked. And this had well, it's been attributed by the CIA to the Russians, and the damage was also considered to be significant to the Democrat campaign back in 2016. And more recently, we saw also at the same time, sorry, back in 2016, we saw similar kind of operations, and in particular disinformation campaigns, and during the same election back in 2016, also attributed to the Russians and the North Koreans and other state and non-state actors. At the same time, back in 2016, so this was a busy year for cyber operations, we saw Russian interference in the Brexit referendum, with a significant impact also in the referendum. So there's a recent report issued on the topic, and more recently, this last year and this year, we continue to see disinformation campaigns surrounding the 2020 US presidential election coming from within the US, and the most prominent person involved in these disinformation campaigns is Donald Trump, as we all know that, and also coming from outside of the United States. Now, what is the Oxford process? The Oxford process is, as I said, a partnership, an initiative that we in the Oxford Institute established with Microsoft, and also with the support of the Japanese government, to try and clarify what rules of international apply, what rules of international law apply to those different scenarios that I've mentioned, and also more generally malicious cyber operations affecting different human rights and different aspects of our lives that are all the more dependent on digital technologies with this pandemic. And the idea is to really bring together experts from academia, state representatives, and the industry to agree on some of the key protections that international law affords to these different institutes or different processes or victims that we've seen in those different malicious cyber operations. And basically, we've chosen to focus on discrete global issues in cybersecurity or in cyberspace. So, for example, attacks against the healthcare sector and disinformation campaigns, more recently supply chain, IT supply chain issues following the SolarWinds hack. So we choose specific issues, and then we try and apply international law to those issues, try and clarify what protections international affords to those issues. And what is important to bear in mind is that we focus on the prohibited or the required behavior of states, as opposed to specific rules. So, for example, we don't delve into whether we're talking about international human rights law, in particular, non-intervention, self-determination, different rules or principles of international law. The idea of the Oxford process is to really focus on the behavior itself, because there's a lot of controversy surrounding the scope of these different rules of international law, and we want to avoid these controversies and agree on the substance, on what is important, what states must do and must not do according to international law writ large. And so the outcome of this process so far is that we've issued 3 statements that kind of like clarify what those protections are. So basically what behavior international law prescribes or prohibits. And we've issued the first statement on operations against the healthcare sector, following, of course, developments during the pandemic, which led to a greater exploitation of vulnerabilities in the healthcare sector. So we've seen, as I said, disinformation campaigns surrounding protective equipment, false medical treatments for COVID. So this was what led to the statement. The second statement was about safeguarding the vaccine research and development, again, following on from those attempts to steal the vaccine, to disrupt the process of research and development and the distribution of the vaccine, different vaccines, including here in Oxford. And then more recently, we had the third statement on international law protections against foreign electoral interference through digital means, which is going to be the focus of today's presentation. Now, unlike the Oxford process, our research into cyber due diligence follows a different approach. So whilst the Oxford process looks at behavior that is prohibited or required in international law in those particular contexts, including electoral interference, the due diligence research really looks at the different roles that international law has, which cover those issues, including electoral interference, right? So basically, the key conclusions of our research, which is being finalized as we speak, is that there is this debate about whether or not there is a particular rule in international law requiring states to exercise due diligence in cyberspace to prevent, for example, cyber interference in elections and other processes. And there's also some debate as to whether there is this general principle in international law requiring due diligence more generally. So there's this debate in the literature vis-a-vis due diligence in cyberspace. And also some advance the argument that actually due diligence is not a rule, not a specific rule, or not a general principle in international law, but it's just a policy recommendation. So it's just a voluntary responsibility that states undertake if they want to, or if as they wish. And so the outcome of our research on this topic is that actually there is a patchwork of different international obligations. So existing international obligations under different systems or regimes of international law apply in cyberspace, or as we call them, information and communication technologies, including those involved in electoral processes. And these different rules of international law, they apply in parallel to require states to behave diligently when they use information and communications technologies, and that includes electoral processes. So basically, we've looked at positive duties under international human rights law, as you can see on the screen. We've also looked at positive obligations under international humanitarian law. We've also looked at some traditional obligations in international law, which are referred to as the no harm principle, the principle that states must not cause transboundary harm to other states. And we've also looked at what we call the Corfu Channel principle, and that's basically the principle that says that states must must not allow other actors to use their territory to commit wrongful acts against other states. So we've looked at all these principles, and our conclusion is that they all apply by default to cyberspace, and they require states to prevent, halt, and redress a range of harms, including online and offline harms, and that is irrespective of attribution. So as I've mentioned earlier, some of those cyber operations, including, for example, disinformation campaigns and the DNC hack, they have been attributed to different actors, the Russians, the Iranians, and so on and so forth, but that doesn't really matter in the context of due diligence. What matters is that the state has to prevent what is within its jurisdiction from being harmed or from being used by other actors to cause harm to other states. So this is the conclusion of our research. Attribution of the specific cyber operations doesn't really matter. So due diligence, in short, is a standard of conduct that is found in those different obligations, and it requires states to exercise their best efforts to prevent, halt, and redress different types of harms. So it's not an obligation of result. The states, they don't have to successfully prevent harm. They just have to try to do what they can to prevent. And it encapsulates the idea, what we call the Spider-Man or the Superman principle, that the more states can do, the more they must do. So that's the idea. So applying this to the electoral context, to the context of electoral processes, what we have is that we can divide these processes or these malicious cyber operations against electoral processes into two types. So on the one hand, malicious cyber operations coming from outside, so foreign cyber operations, and on the other hand, domestic malicious cyber operations. So looking at foreign cyber operations, the legal framework that we have right now under international law is that the Corfu Channel Principle, and this was a principle that was articulated in the very first case before the International Court of Justice. This principle says that states must not allow their territories to be used for acts that are contrary to the acts of other states. So basically, if you have a foreign actor, a foreign state actor, or a non-state actor allowing its territory to be used to interfere in electoral processes in other states by digital means, that means, and if that is contrary to the rights of other states, that is prohibited under international law. And these rights of other states that might be affected by interference in electoral processes include sovereignty. So if a state interferes in the elections of another state, including by digital means, that might violate the victim state's sovereignty. It might also violate the principle of non-intervention under international law. That's another right of the victim state that might be affected by electoral interference. And there's also this other principle, as I said, in international law, which is called the no harm principle. It's usually associated with environmental harm, but it basically applies to all kinds of significant transboundary harm against persons, objects, or the territory of another state. So for example, if you've got state X that even in lawful activities in that state, if harm originates from that state, including by digital means, and that harm crosses a boundary and affects another state, and this could be electoral interference, then that might be prohibited as well under international law. So as I said, harm is broadly defined, and it includes both physical and non-physical interference. So if a state interferes in the elections of another state by non-physical means, by digital means, for example, using disinformation campaigns, and that causes harm. So for example, if that affects the ability of the electorate to go and vote, that will be covered by the no harm principle. And so the origin state has a duty to prevent that conduct from originating from its territory. And as I said, this principle covers both lawful and unlawful activities. So even if under international law, disinformation of a non-state actor is not prohibited, the no harm principle would still require the origin state to prevent it. Now, international human rights law is broadly applicable to the same kind of scenario, with one caveat, and that caveat being extraterritorial jurisdiction, right? So there is this debate in international legal discourse and international legal scholarship as to whether or not there is extraterritorial jurisdiction for human rights. So basically, under some human rights treaties, we have jurisdiction as a precondition to the applicability of human rights, and that includes the rights to vote, the rights to freedom of assembly, the rights to freedom of expression, privacy and freedom of thought, self-determination, all of which are implicated in the electoral context. And so the debate is, do we have extraterritorial jurisdiction? So do these rights apply beyond a state's territory? So for example, let's say Russia. Does Russia have an obligation to respect and to protect human rights beyond its territory? And that, of course, depends on the model of jurisdiction that one follows. I particularly follow under human rights treaties, and in particular the International Covenant on Civil and Political Rights. I follow what we call the functional approach to jurisdiction, which means that jurisdiction extends insofar as the state controls the enjoyment of the human right in question. And this is an approach that has been endorsed by the Human Rights Committee more recently. But there are more restrictive views about jurisdiction, and I won't go into much detail. And as I've mentioned, human rights law covers both covers positive and negative obligations. So obligations to respect human rights and obligations to protect human rights. That is, obligations to prevent harm to human rights by third parties. And so this includes, in the electoral context, both obligations of the origin state. So for example, the state from which the malicious cyber operations they emanate from, let's say Russia in the case of disinformation in the US, And it also includes obligations of the victim and or target state. So basically, in, let's say, the US, if it's the victim of disinformation campaigns originating from abroad, it also has a duty to protect its citizens, those under its jurisdiction, to protect the rights of those under its jurisdiction from these malicious operations. Now, looking at the domestic context specifically, international law also applies. So it's not just domestic law that applies in the domestic context. And here again, we're talking about international human rights law. And here jurisdiction is not contested because we've got territorial jurisdiction established. So a state has human rights obligations under human rights treaties that it has ratified, and there's no question that these obligations apply in the state's territory. And here we're talking about the right to vote, the right to freedom of expression, the right to freedom of assembly, freedom of thought, and also the positive obligation. And this is the state's, the victim state's positive obligation to protect those individuals within its jurisdiction from malicious actors, even if those actors are based domestically. So a state has an obligation to protect human rights, even if the threat to those human rights emanates from within that state's territory. Now, as I said, we've covered some of those topics in the Oxford Statement on electoral interference. And of course, the statement is very broad, comprehensive. It covers all range of rules of international law that apply, although we don't specifically mention what rules we're talking about. We do cover a wide range of behavior, but I won't go into all of those rules, and I'm only going to be focusing on protective obligations, or protective duties, and that is states' obligations to protect elections from harm, either from domestic harm or from foreign harm. And so the first thing to bear in mind is that the Oxford Statement, it applies to all electoral processes, and this is clear from the preamble and from the operative paragraph 1. We've chosen in the statement to focus on foreign electoral interference as a means to gather more consensus, because there was the debate about, should we be talking about a state's own obligations vis-a-vis its own population? Is this not a matter of domestic law? Should we be talking about international human rights law in this context? So to avoid those debates, we've chosen to focus only on foreign electoral interference. And basically the operative paragraph 1 talks about international law, and it says that it applies to cyber operations by states, including those that have adverse consequences for the electoral processes of other states. And this statement basically means that international law applies in cyberspace, and that includes the electoral processes of other states if they take place through virtual, through digital or physical means. So that's what this paragraph is about. And as I said, the statement covers all kinds of electoral processes, referenda, plebiscites, elections, and it covers all stages of an electoral process. So it covers balloting, so basically the registration of voters, casting votes, tabulating, counting votes, verifying an election. So all of that is covered by international law to the extent that this is part of an electoral process. And what is also interesting about the statement is that the statement also covers the stage before the election. So that is information that is provided to the public before and during the election. And this includes information about how to vote. So for example, where should I go to vote? What is my jurisdiction? How should I cast my vote? Can I vote by mail? So this is what we call procedural information. And the statement also covers what we call substantive information about candidates. So who is running for office? What is this person? What is this person's background? What does this person do? Who exactly, what it is that this person is doing. So if there's any interference with the publication or the dissemination of these types of information, procedural and substantive, and if that interference cause significant harm to the victim state, the state conducting the election, that might potentially be covered by the statement and international law more generally. And also it's important to clarify that what we mean by adverse consequences, we mean anything that might cause harm or might undermine the process, the electoral process as a whole. And so that includes conduct that interferes or intervenes in the election, or that undermines public confidence. And this includes broadly anything from intrusion into the system, so registration systems, ballot counting systems, if those are digital, but also hacking and leaking, as the DNC hack as well, and disinformation campaigns and phishing campaigns. So for example, if you've got an email saying, well, your voting information, we've got your voter information, and if you don't vote for this candidate, you will suffer some backlash. All of this is covered to the extent that this causes harm. It's covered under international law writ large. And so basically what we have is that international law applies to all of those different components of an election: the human component, the physical component, the digital component, a range of different actors that are involved, as well as the different stages of an election. As I said, registration, casting ballots, counting of votes, and verifying the results and disseminating those results. So if there's any interference with any of those stages, those might be covered by international law. This is what the statement says. Now, the statement also deals with due diligence, which is what I said earlier. And as I said, we basically don't name the different rules to avoid contestation, to avoid controversy as to the source of the obligation. But we basically cover both the Corfu channel and the no harm principles. And what we basically clarify in the statement is that states must take all measures that are feasible to prevent interference arising or originating from their territories and affecting the territories or the electoral processes of other states. And this includes investigation, this includes monitoring measures, this includes measures to remedy the effect of electoral interference if it has already happened, information sharing, legislation on cybercrime, and content moderation. And what is important to also to bear in mind is that all of this has to be carried out in accordance with other rules of international law, and in particular human rights law. Finally, the other thing that is important to note about the statement is that the statement also provides that a state has an obligation to protect and ensure their own. So this is what I call, this is the domestic aspect of foreign electoral interference. So basically the victim state also has an obligation to safeguard its electorate from these foreign interference. So basically, let's say the US government also has the obligation to safeguard its own population from foreign electoral interference. And this is what we are referring, basically, we are referring to positive obligations under international human rights law, or domestic due diligence. And this means that the state, the victim state, has to protect the rights to vote, the rights to freedom of assembly, freedom of expression, freedom of thought within its own territory from foreign interference, bearing in mind, of course, the limitations under international human rights law. And that means that limitations have to be legal, they have to be legitimate, they have to be necessary, proportionate, and non-discriminatory. Now, just a summary of what I just said. Basically, what international law requires is quite a comprehensive range of due diligence measures that both the origin state, so the state from which the threat arises, and both the victim state must adopt. And so you've got this beautiful diagram here that I've borrowed from Dan Blum. And basically, there's a range of measures that states might be required to adopt under international law to protect their electoral processes, and also to protect their territory from being used to harm other states' electoral processes. And so basically, as I said, this includes cybercrime law, content moderation. Also important is to raise awareness individual awareness, public awareness, citizen awareness about disinformation campaigns. This is really important. That's what we call cyber literacy, to develop critical thinking in citizens, to develop public-private partnerships, because most of the internet is privately owned. So we need the cooperation of the industry, of corporations, to be able to monitor those threats. So for example, Microsoft and IBM are very active in this regard in sharing information to government and governmental bodies. And as I said, sharing information, sharing vulnerabilities are also important. So there's a range of measures that international law might require, and there's a range of different rules that apply to the electoral interference scenario, the foreign electoral and the domestic electoral interference scenario. So just some concluding thoughts here from our research more generally is that we don't really need new legal rules or concepts to address this kind of scenario. We already have a range of rules that require states to prevent, halt, and respond to cyber harms, including electoral interference. And this includes electoral interference from within and from outside a state. But we do need to understand how international law applies in particular to this kind of scenario and to cyberspace more generally, because there's a lot of uncertainty as to what cyberspace really is, how it works, what are some of the peculiarities of it, which make it hard to apply traditional rules of international law to this new phenomenon. So that's it from me. I couldn't see the chat, so I don't know if I ran out of time, but I hope I didn't, and sorry if I did.
Yeah, thank you so much, Talita. And we'll turn to, we already have a question in response to your presentation. We'll turn to that afterwards, just to make sure that Gauri has a chance to speak. So turning it over now to Gauri Ramachandran. Thank you.
Hi, thank you so much for having me, everyone. I really appreciate the opportunity. And it turns out I didn't know what the content fully of Talita's presentation was going to be before, but it's a perfect segue into what I want to talk to you about today. So I've been working at the Brennan Center since about July 2019. And the reason I came to the Brennan Center is that I felt that election security was just so important in the recent election we had, and I wanted to devote my energy to it. So I thought I would tell you a little bit about what I did for the last year and a half to advocate for improved election security in the United States, and then talk about some areas of improvement that we need going forward. But the reason Talita's presentation was such a great intro to what I'm going to talk about is that essentially what I spent the last year and a half doing was advocating for states and local election officials to carry out that obligation to exercise due diligence to prevent against actually really both foreign and domestic interference. So, and you know, the summary is that overall election officials here in the United States, they did do a heroic job at engaging in that due diligence. So many of them, particularly in battleground states, they created these layers of security and resilience in their systems in order to defend against any potential cyber attack and also to bolster public confidence in the results of the election. So they engaged in the idea of detecting, preventing, and recovering from any attacks were they to occur. And I think, you know, before I get into the details of some of the things they did, I would say, I think that attempted insurrection on January 6th, after all that, it's really a stark reminder of why election security, election access, voting rights, why those things really are human rights, because they are like the bulwark against racial oppression and ethnic violence and political violence. I think, you know, it's no coincidence that the same people who were saying stop the steal and invaded the Capitol were carrying Confederate flags and wearing t-shirts that glorified the atrocities at Auschwitz. And it's because the votes that they didn't want to count and the votes that they didn't think should count were Black and brown people's votes. So that's why, you know, the legislators that you saw objecting to counting all of the electoral votes, they objected to counting votes in Pennsylvania on the grounds that they said the Pennsylvania election officials had sort of exercised their emergency powers to change the rules in order to accommodate the needs of voters during the pandemic. And the state courts had approved and said that was they did have the authority to do that under Pennsylvania state law. But these legislators said, well, you know, you're not actually allowed to do that. Only state legislators get to change the rules during the election. But notably, they didn't challenge the electoral votes in North Carolina, where I think many of the students are, or Texas, where actually exactly the same thing occurred. So the governor in Texas issued emergency regulations to accommodate voting during the pandemic. The chief election officials in North Carolina did the same. And just like in Pennsylvania, the state courts in those states upheld those interpretations of the law and those exercises of authority, as they have often in other disaster situations like hurricanes. I'm sure those of you in North Carolina who grew up there are familiar with those kinds of instances. So yes, I think these rights were under threat from foreign interference in 2020, but they were also under threat from just racially motivated domestic strife and a kind of domestic unwillingness to recognize others' equal legitimacy as citizens and equal access to democratic processes. So with that said, I thought I'd start by telling about some of the things that were done here in the US to protect our citizens against those threats, while also protecting them from COVID-19, ensuring voters could exercise their rights in a relatively safe manner. So a huge protective measure that was taken between 2016 and 2020 is that by November 2020, almost all states and counties in the United States have moved to a paper ballot-based system. So for instance, North Carolina, Georgia, Pennsylvania, they all eliminated the use of what's called a direct recording electronic device, which is a machine that sort of digitally records votes, but doesn't leave any kind of paper trail. So it's not auditable because there's no paper record. And almost all states in the US had eliminated those kinds of machines and instituted the use of either hand-marked paper ballots or ballots that touchscreen voting machines that leave a paper trail. So that's just one example of building up resiliency to potential attack. And we actually saw that resiliency matter and be carried out in the 2020 election, because when disinformation was spread by President Trump and others about the legitimacy of the tabulation of votes in Georgia specifically, the fact that they had that paper record for the first time in a general presidential election in Georgia meant that the state was able to conduct a hand count and say it doesn't matter if those tabulators were misprogrammed by foreign actors or any of that, because we actually are able to look at every single paper ballot by hand, look at the human readable text on it that says Biden or Trump or whoever it is the person voted for, and count them all up by hand in public view, and the result came out the same. And so it was really important that states took that preparatory measure before the election. Other things that they did is officials all over the country, they participated in what's called tabletop exercises, which is sort of like sitting around a table or a Zoom room once the pandemic hit and pretending that various crises happened, various cyber attacks, forms of interference, and just talking through like, okay, what would I do? Who would I call? Who are my contacts at the Department of Homeland Security? And officials all across the country participated in those. The Brennan Center organized some of those in partnership with Microsoft and CISA, Department of Homeland Security. So there was a lot of just practice to be ready for crises by officials. And then a lot of officials engaged in those resiliency measures that Talita was talking about, having backups in case of system failure. So one of the things I did is I advocated at kind of a hyper local level in a lot of states and counties for officials to have emergency paper ballots ready in case those touchscreen machines broke down. So that lines would keep moving, people wouldn't have to stand around. They would have those emergency paper ballots that they could resort to. And that actually also happened to come in handy during the runoffs in January 2021. So for instance, there was a county in Georgia during those runoffs where they had difficulty getting those touchscreen machines to work. They resorted to using the emergency paper ballots that the state had agreed to mandate all the counties to keep on hand. And so it was fine. Everyone was able to vote. And that was a sort of Republican stronghold county happened to be. And when President Trump, tweeted out about this disruption and claimed that something nefarious was happening, the state officials were able to say, look, we had the emergency paper backup. It was deployed immediately. Nobody was turned away or lost their ability to vote. And despite, that really big megaphone that President Trump had, that particular form of disinformation, at least, did not actually lead to any sort of failure in confidence in the election results, any contestation of who the legitimate winners were. So, we were advocating for all of these measures even before the pandemic hit, and having a lot of success really in getting states and local officials to adopt them. And then, of course, the pandemic hit. And so we thought, okay, how do we need to update our advice in light of the pandemic? And it really turned out that honestly, election officials just still needed to do all the same things because the threat of interference and cyber attack, it didn't go away, of course, when the pandemic hit. If anything, the threat surface kind of increased because so many more people were working remotely, using personal devices, home Wi-Fi, that sort of thing. And having sort of access and options for voters like online voter registration, early voting, vote by mail, all of that sort of itself turned into the resiliency measure that helped the election go relatively smoothly despite there being this pandemic. So it was a lot of work for election officials. It was tons of sort of under-resourcing, honestly, because they were essentially conducting 3 elections, an early election, a vote-by-mail election, and an election day in-person election in order to accommodate all these different needs of voters. And I would say that that sort of under-resourcing and that difficulty that they went through in order to pull it off, it's really indicative, I think, of how we have a history in the United States of under-resourcing state and local governments in a lot of different ways. So public health, local public health, we've discovered has been really severely neglected in the United States, in the same way election administration has been neglected. And these things really do have a disparate impact on communities of color. We've all seen the disparities in the pandemic. It's also well documented that voters of color are much more likely to stand in long lines than voters not of color or voters in majority white precincts. And all of that is really due, I think, to systemic neglect and under-resourcing and kind of disparate needs, honestly, in different communities. Some communities have to provide ballots in 4 different languages as opposed to just one, and staff their precincts in that way. So I think that ultimately, we had essentially a success story in a way in this election, because despite all the challenges, we did actually pull off a legitimate, free and fair election. Obviously, the events of January and February show that there's a lot more to be done, I think, in terms of that piece of it that Talita mentioned, which is the obligation to inform the public and have accurate information for the public. Election officials did invest a lot in communications and voter education and combating disinformation, but we clearly need to provide them with more resources, I think, to combat what is really just a fire hose of disinformation when it comes to elections. I think that's kind of like the next step in terms of fulfilling those obligations that Talita talked about, that we have to devote the resources to in the U.S. And I'll stop there because I know there may be questions. I really would love to interact with the audience and hear what you think.
Great. Thank you so much, Gauri, and to both of you for the really comprehensive presentations. We'll start with, we have a question from Professor Helfer, directed at you, Talita, on this excellent and comprehensive presentation, and a question about whether or not states have recognized that the principles in the Oxford Statement reflect existing customary international law, and if not, what steps could be taken to encourage recognition of the principles.
So thank you so much for the question. That's actually a great question. So what we did with the statement is to try and reflect agreement by states, so existing agreement by states and existing customary international law. So everything that we put in the statement was already part of customary international law or treaty before we put it in the statement. So we were very, very careful to select just the rules that we thought there was enough consensus about their applicability, either in the customary international law or treaty law. Now, and this is why, for example, we omitted the whole debate about jurisdiction and the different models of jurisdiction. So this is not in the statement because, of course, there are controversies as to what type of jurisdiction is customary international law. Now, whether or not states have recognized the statement itself in the way that we framed it, that's a different thing. So we've had at least one state explicitly referring to the statement. So basically, that's the Dominican Republic. which cited our statement in one of the Security Council area formula meetings back in May of last year. We had also other states that have approached us, not publicly, they have approached us expressing approval of the way that we phrased existing customary international law. And we've also observed that some states have referred to, well, not explicitly to the statement, but they've kind of they've used similar language. So we're kind of happy to see that that there's a real impact of the statement and the way that states are framing their views. But the point is, whatever is in the statement was already part of existing international law, including customary international law. Now, how can we encourage recognition? So what we're trying to do is to encourage states to accept the things that are a bit more controversial. So for example, there's this debate about whether or not sovereignty is a rule of international law that can be breached, or whether it's just a general principle of international law. And what we've been trying to do really is to continue with other statements on other topics and hopefully get enough agreement in academia and hopefully get states. Well, actually, most states agree that sovereignty is a rule. The only state that hasn't agreed, that explicitly rejects, for example, that is the UK, and the US is a bit ambivalent. So there are some gray areas there, we recognize, but we've been doing a lot of advocacy, a lot of workshops, and a lot of conversations with state representatives to get this recognized in official documents before what we call the open-ended working group on cybersecurity, or the group of governmental experts on cybersecurity, both at the UN. So that's what we've achieved so far.
Great, thank you, Talita. And there's a question from the audience about what individuals can do, and I wanted to build on this as well and ask you, Gauri, specifically. I was really struck that you said that many of the recommendations from the Brennan Center did end up being taken up by different local and state officials. And I know that the Brennan Center issued a report on preparing for cyber attacks and technical problems, which included a checklist. And so, again, the fact that this was quite successful, I wonder if you could trace a little bit more what that advocacy looked like on the part of you and your colleagues at the Brennan Center, and then to link into the audience question, if there's also ways in which law students and lawyers can also contribute to this kind of advocacy going forward.
Mm-hmm. Yeah, I'd be happy to talk about that. So it's interesting, a lot of the other sort of advocacy groups in this context, and particularly groups that are very focused on voting rights, they've tended, I would say, and I'm really generalizing here, but tended to take a sort of like litigation approach to ensuring access and all of those sorts of things, right? So there's long lines, sue and say you have an obligation, you know, under whatever, usually domestic laws is what people have used under the Constitution to do a better job serving your voters, because if you don't, their rights to vote will be undermined, right? They'll be disenfranchised. The Brennan Center election security team just happens to, you know, through circumstance, occupy a slightly different space. We tend not to go the litigation approach, although our voting rights team does do a really pretty significant amount of litigation, which is important. But our technique has really been to work cooperatively with election officials. So things like that guide you mentioned, Aya, like provide it as a resource, conduct those tabletop exercises for election officials and organize them. We did like an educational series with Microsoft. So that way we're seen as more of a, you know, partner. And then when we advocate for, you know, you really need more emergency paper ballots, Fulton County, because you guys ran out during the June primary, we have a little bit more of a, you know, cooperative relationship where that recommendation can be seen as something that's really there to bolster the officials carrying out their duties, as opposed to something they're being required to do. But it's certainly complicated, and it was certainly complicated during this pandemic, because obviously state and local budgets were just cratering. So asking someone to spend extra money for extra resiliency, extra security for voters, when they barely have enough money to conduct sort of business as usual, it's a tough ask. So we also sort of combine our cooperative and local advocacy with more traditional advocacy on the federal level to try to get funding for elections. And that was a big part of the work that those on my team did in the run up to the election, is to try to get those resources in place also, because yeah, we sort of follow a philosophy that the resources and the funding are a crucial part of actually carrying out one's duties to provide free and fair elections and support democracy. You can't just do it by refraining from violating the law. You also have to really put in the investment and the resources.
I have a couple more questions, but again, if there's anything from the audience, please feel free to send it through. And I wanted also Talita and Gauri, if you had any questions for each other, sort of working on, very similar issues, but in different contexts, if there was anything that you wanted to engage with one another on.
Well,
I have a question. Oh, go ahead, Talita.
No, go ahead first. I just wanted to say that it's incredible to hear about your work on what types of measures have actually been adopted, because that's exactly what we try and do on a more sort of like transnational level. We try to kind of like map what states have been doing, what and give them guidance, because it's one thing to say, oh, you have this beautiful obligation in the international human rights law, for example, but then how do you enforce it? And that's exactly what you've been doing. So I'm very, very happy to see that there is someone doing this kind of work. So I'll be sure to look out for your work. And I thought that I just have a comment really just to say that it's that actually the point that you made out having paper ballots, making sure that you have auditable results, that is exactly our line of thinking. And we actually thought of spelling out those measures in the statement, but then in the drafting process. So this is an insider information, but then we thought, well, let's leave it for states to adopt what they feel that they're able to, of course, if they have the resources, as you've mentioned, because that's something important. But just to say that those measures that you've mentioned were exactly the same kinds of measures that we're thinking. And I completely agree with you that we need more effort into tackling disinformation. I think that's the biggest problem that we are facing, not just in the electoral context, but in all contexts. And we need social media corporations to be on board and to actually do something. And I think that what they've done in the US came a little bit too late, in my personal opinion. I don't know if you share this view, but
yeah, I do. And I actually, the question I had for you, Talita, was I thought it was interesting that in the statement you focused on foreign interference in order to get more, more signatories. Do you think that after what's happened here in the US recently, there would be more appetite for signing on to something that really articulates that obligation to inform the public in response to domestic strife as well? Or do you think there would be even less because it's, at least in the US, become so politicized?
I think the short answer is there is more appetite, and we are doing another round of conversations on disinformation and online hate speech because of the Capitol riots. So we've seen, I think that sometimes people only act when damage is already done. And this is the problem, right, with due diligence and with prevention. We need to think ahead. And I think that the problem, in academia and in legal practice is that we only take action when the problem is already out there. So I think that I hope that this is what it takes for us to kind of like tackle the issue and that things don't get worse. But there's definitely more appetite, absolutely, because we've seen that the threat is not just from foreign actors, and it's arguably worse from within, because as you've mentioned, CISA was successful in preventing the infrastructure, the backbone of the election infrastructure, from foreign interference. Right, they were very successful, and this is why Chris Krebs was fired from his position, because he said, well, we've been successful in avoiding foreign threats, but the threat actually came from within, and from the disinformation and from the hate rhetoric within the US. And this is something that needs to be addressed urgently. And as I said, not just in the electoral context, but more generally by educating the public. And this is where we have a role to play.
Thank you, Talita. So we're just about at time. So I want to, again, really thank you both, and especially for ending on that, I think, really important note about the preventative aspect being so important, which of course is also an important element of the due diligence obligation under international human rights. And so that combination of prevention and then the real building of resilience, as you also highlighted throughout Gauri, and working with the public and that information sort of spreading component as well. So really, really helpful to have both of your, again, really complete and thorough analyses of this issue, and some of the really practical recommendations, and also steps that actually were taken successfully in the election process in the US in particular. So thank you again to both of you, and to our audience for joining, and to our future audience who'll be watching this through the recording. So thanks so much, everyone.
Thank you.
Thank you so much. It was a pleasure.
Thank you.